Case dismissed with prejudice. 4 words. That's where it ended. 4 words and a single bank statement. An indictment the government spent 2 years constructing, folded like a cheap suit. Judge Anthony Rossi didn't shout. He didn't have to. When a federal magistrate tells the state their entire narrative is a fabrication, silence does the heavy lifting. The defendant, a man who'd been staring at the defense table watching his future evaporate, raised his head. For the first time in 20 months, he wasn't staring at a cage. He was staring at the exit. And the district attorney? You could witness the color vanish from his skin because he realized what was in that file. Witness 9 was bought, and Judge Rossi had the proof. So how does the state's key testimony wind up on a payroll? One transaction, one offshore account, one digital footprint they figured was buried deep enough to stay hidden. They figured wrong. But here's the part that makes this whole situation rot. This wasn't a clerical error. This wasn't a misunderstanding. This was a strategic, cold-blooded choice to bribe a witness to bury a man looking at 30 years. 30 years! Let that sit with you. A human being was sitting in a dock watching his legacy get wiped out. And the guy sworn to tell the truth? He was cashing checks. I've analyzed a ton of trials on this platform. Bribery, misconduct, overreach. I've seen the worst. But this one made my blood boil because the mechanism failed. The mechanism ignored this. The mechanism was actively shielding this until Judge Rossi tore the blindfold off. The moment the internet is obsessing over, when Rossi threw the case out the window, it's coming. But first you have to grasp what the state pulled. You have to understand the scale of this. And believe me, it's darker than you think. Here's the real story, the minute that's snapping the legal community in two. May 12, 2024, Federal District Court, Southern New York. The trial of Elias Thorne had been dragging on for a month. RICO statutes, wire fraud, conspiracy, the type of indictment that builds reputations. The government had thrown the kitchen sink, and their ace, Witness 9, a guy they protected but who was supposedly in the room for the money drops, the silver bullet, the guy who could link Thorne right to the operation. Judge Anthony Rossi, 25 years in the robes, ex-Marine Corps JAG, known for running the strictest docket in the circuit, had been observing, still, precise, the sort of jurist who memorizes the transcripts and never forgets a discrepancy. Defense counsel Elena Rodriguez had been chipping away at Witness 9's story for a week. Tiny contradictions, memory gaps, but nothing fatal, nothing that would shatter the narrative. Until discovery. You see, Rodriguez's firm had lodged a request weeks back asking for total financial transparency on all state assets, routine protocol in capital cases. The state fought back, filed motions to quash, cited sensitive intel, ongoing ops, witness safety measures. Judge Rossi overruled every single refusal. His specific language in the ruling? The prosecution's hesitation to offer fundamental financial clarity invites suspicion this bench cannot overlook. So, the state caved. Mostly. They surrendered blacked-out files that were meant to show Witness 9 had no monetary link to the investigation. But Rodriguez's auditor spotted something they buried. A deposit, $52,000, funneled through a holding firm in Nevada. The firm's listed manager? A corporation held by the lead prosecutor's brother-in-law. The cash landed in Witness 9's ledger 4 days prior to his initial deposition. When Rodriguez displayed this on the record, you could hear a pin drop in that hall. The DA protested, called it speculative, claimed the defense was spinning a conspiracy out of thin air. Judge Rossi asked one thing: does this transaction exist? The DA froze. That silence hung there for maybe 3 seconds. But in a trial, 3 seconds is a lifetime. Your Honor, we were not comprised of... Answer the inquiry, counselor. Does it exist? Affirmative, Your Honor. But Rossi raised his palm. He didn't need to hear the excuse. He suspended proceedings for 48 hours. Everyone assumed he was pondering. Everyone assumed he'd return with some cautiously phrased decision about moving forward with care. They were mistaken. When the session resumed, Rossi didn't take his seat. He stood at the dais, stared straight at the government's table, and handed down a judgment that law schools are going to be studying for generations. The state's indictment relies upon the assertions of a witness who accepted significant funds from sources linked to the prosecution. This bench has analyzed the banking logs. This bench has analyzed the timeline. This bench concludes that the veracity of this testimony has been fundamentally, irrevocably shattered. He stopped. Case dismissed. With prejudice. With prejudice. That means the government can never file these counts again. Never. Elias Thorne walked out of that hall an unchained man, and the district attorney's office walked out with their reputations in ashes. But here's the curveball nobody predicted. As Rossi exited the bench, he signed one final mandate. This one classified. Within hours, the DOJ launched an internal inquiry, not into Elias Thorne, but into the prosecution. The trial didn't just stop, it flipped. And when I say the shockwaves from this are still spreading, I'm not being dramatic, because what Rodriguez's firm uncovered in those bank files, that $52,000 wasn't the only deposit. There are more informants, more transfers, more trials, and Judge Rossi just kicked down a gate that nobody wanted unbarred. If you're viewing this thinking, finally, someone is exposing what actually goes on in these tribunals, smash that subscribe button right now. I'm just scratching the surface of this saga, and believe me, you're going to want to witness where this leads. But not everyone views this as a win for the law. The district attorney's office published a memo within hours, branding Judge Rossi's decision a reckless judicial overreach that values procedural loopholes over community safety. And honestly, when you listen to their reasoning, you might see why some folks are anxious. Their stance is this: Elias Thorne is not a saint. The other proof, body cam video, encrypted logs, physical evidence, still stands. Witness 9 was backing up a story that the state argues was already proven by separate sources. One ex-state attorney phrased it like this: the magistrate tossed an entire indictment because of a bank transfer that might have had a totally harmless reason. We don't know what that check was for. We don't know if Witness 9 was even aware of it. This verdict means every defendant in the country now has a playbook for getting charges dropped. Just locate something, anything that looks fishy, and argue the whole case is poisoned. Legal Twitter blew up with opinions from both camps, but a shocking number of experts, including those who usually slam prosecutorial misconduct, are asking tough questions. Was Judge Rossi correct about the bribe? Absolutely. But was trashing the entire docket with prejudice the right fix? That's where people split. Legal ethics scholar Jonathan Vane, who has presented before the Senate on court standards, noted this issue. The problem here isn't about shielding a dirty prosecution. The problem is balance. If a source is tainted, you strike the source. You don't necessarily incinerate the whole trial. Rossi's judgment, however righteous it feels, establishes a standard that could have chaotic side effects. So who is correct? Did Judge Rossi serve justice, or did he let his rage at government corruption overpower the actual facts against Thorne? Is Elias Thorne actually guiltless, or did a criminal just skate because the state got lazy? That's the riddle nobody wants to solve, and the deeper you burrow into this, the murkier it becomes. But this didn't happen in a vacuum. Long before this detonation, the red flags about this legal team were waving. In 2018, this same DA's unit faced a misconduct filing for burying clearing evidence in a narcotics ring trial. The request was rejected, but the judge's written ruling contained a sentence that should have been a siren. The state's behavior in this instance toes the edge, but does not quite step over the line of prosecutorial malpractice. Toes the edge, but doesn't step over. That's legalese for you dodged the bullet this time. Did they learn from it? What do you reckon? In 2021, a separate indictment from that same division imploded when defense counsel found out a primary snitch had been scripted on his statement. Not just prepped, but actively scripted on what to speak and how to phrase it. That trial was tossed too, though without prejudice. The accused eventually took a plea for a minor count. And in 2022, an insider within the Bureau, a clerk who'd been on the payroll for 12 years, lodged a grievance with the DOJ Office of Professional Responsibility, claiming a habit of result-oriented evidence managing. That grievance was probed briefly, quietly, and ultimately buried with no disciplinary measures. Every time the machine blinked, every time the division kept running, every time the same attorneys kept constructing files, kept going to court, kept begging juries to believe them, until Judge Rossi said enough. What makes this verdict distinct isn't just what Rossi uncovered, it's what Rossi did with what he uncovered. Most jurists would have penned a sternly worded order, maybe struck the witness, maybe called a mistrial. Rossi didn't offer them that escape hatch. He didn't give them a shot to retry. He killed it dead and passed the wreckage to the feds. The board was set. The state just didn't realize they were stepping into their own snare. Smash that like button if you track where this is heading, if you grasp why this saga is about more than just one accused man and one informant. The actual narrative, the story about what drops next, is arriving and you need to witness it. And then it struck, the moment that flipped the script. The hall went dead. Not hushed. Dead. The type of stillness where you can hear folks inhaling. Judge Rossi stood at the dais. His expression was disciplined, but if you stared, truly stared, you could spot something in his gaze. This wasn't a magistrate handing down a standard decree. This was a man who had viewed something that repulsed him. The bench has examined the defense petition in total, he stated. The bench has isolatedly authenticated the banking logs submitted, and the bench has arrived at a determination. The DA was already upright. Your Honor, if I might, you may not. Rossi's tone was liquid nitrogen. Take your seat, counselor. He sat. In my 25 years on this circuit, I have witnessed ineptitude. I have witnessed blunders. I have witnessed the occasional error in logic. Rossi waited. What I have not witnessed until today is a strategic, paper-trailed plot to purchase testimony, to fabricate proof, to poison the administration of law itself. He stared right at the government's desk. Case dismissed with prejudice, and this bench is forwarding this issue to the FBI's Public Corruption Unit for instant inquiry. 52 seconds. That's all it took. 52 seconds, and Elias Thorne went from staring at 30 years in a federal cage to stepping out the front gate. But here's what nobody caught while they were watching Thorne's face. The lead attorney didn't fight, didn't protest, didn't lodge an immediate notice of appeal. He packed his satchel in total silence, rose, and marched out of the hall without locking eyes with a soul. His junior associate was trembling, actually physically trembling, because they realized something the rest of the gallery didn't. They realized what else was in those banking logs. This wasn't an emotional response. This was a strategic retreat. And that should frighten anyone who gives a damn about how the law actually functions in this nation. Stay right there. What I'm about to expose changes the whole frame of this report. Drop a comment right now. How many other trials do you figure are tainted by this? I want to see your guesses before I display what I dug up. Folks who work this beat are dubbing this the most monumental judicial strike against prosecutorial corruption in a generation. One ex-federal attorney, someone who's litigated over 70 trials and now lectures at Harvard Law, broke it down like this.
What Judge Rossi did was declare war on a tradition of exemption. For decades, prosecutors have worked under the belief that small infractions, even major ones, will be handled through internal reviews. They'll get a mark on their record, maybe a memo in their personnel file, and carry on. Rossi just proved that there's another path, that a judge can and will incinerate their case completely if they step certain boundaries. What does that mean in plain English?
It means state attorneys everywhere are suddenly staring at their witness rosters and asking what a defense counsel might dig up. And here's what defense lawyers are muttering to one another. Every open trial with snitches just became fair game. Every monetary link, every deposit, whether it appears clean or not, defense firms are going to lodge petitions citing Rossi in every federal jurisdiction in the states. But it's not just the defense bar cheering. Even ex-partners of the state are confessing there's a glitch. A former DOJ supervisor who served in that same circuit noted something stunning. The nasty reality is that Witness 9 likely wasn't a solo event. When you design a machine where guilty verdicts dictate promotion, you design motives for precisely this sort of conduct. Rossi didn't reveal one dirty trial. He revealed a shattered reward system. The signal is plain. This judgment isn't just about Elias Thorne. It's not even just about this legal team. It's about whether the whole federal penal apparatus can be relied upon to regulate itself. And judging by what we've witnessed, the response looks to be negative. Crush that like icon if this is clicking, if you grasp why this counts beyond just one indictment. The code promotes clips that get interaction, and this is the sort of narrative that demands to be viewed. Assist me in making that occur. So, what does this signify for you? Right now, defense counsels across the nation are submitting urgent petitions, tons of them. Every indictment that included informant testimony from this DA's bureau is suddenly under the microscope. Here's the rub. If Witness 9 was compensated, who else was? That's not a rhetorical inquiry. That's the inquiry that's going to rule federal criminal defense for the coming year. If you know anybody currently staring down federal counts with snitch evidence, this ruling just flipped everything about their reality. In the coming 30 to 60 days, anticipate multiple indictments to be fought on parallel logic. Some will win, most won't. Rossi's rejection was grounded in paper proof, not guesswork. But the probes sparked by those filings, those could reveal more. If you're tracking federal criminal trials, you're about to witness something unique. Prosecutors on the ropes, explaining themselves, defending their bonds with informants. For the first time in ages, the government is going to have to demonstrate it played by the book. But the grander view, that's what keeps me awake. If this standard sticks, if Rossi's method becomes the norm rather than the outlier, it implies the whole vibe of federal litigation has to shift. Informants will face unheard-of auditing. Financial ties will have to be laid out early, not unearthed in discovery. Every federal hearing from now on will be altered. And here's what no one desires to discuss. How many souls are currently in cages based on stories that were bought? Think about that. Truly ponder it. If this division paid Witness 9, and if this wasn't their debut, then there are folks sitting in blocks right now, today, who were put away on fabricated proof. We're not speaking about loopholes. We're not speaking about guilty folks who happen to have their rights infringed. We're speaking about potentially guiltless humans whose existences were wrecked by attorneys who decided winning mattered more than honesty. That's not a cozy thought, but it's the thought that Judge Anthony Rossi just compelled the whole nation to entertain. And the Department of Justice doesn't have a reply. Not yet. Maybe not ever. And then the state made it uglier. 24 hours after the rejection, the district attorney staged a media briefing, not to say sorry, not to admit fault, to assault Judge Rossi. Judge Rossi's verdict mirrors a basic ignorance of how federal probes function, he stated. Financial aid for sources who brave personal danger is not bribery, it is security. And this judgment places lives in peril. Instead of owning it, they opted to double down. The internet reacted exactly how you'd predict. Legal Twitter shredded the release sentence by sentence. Former state attorneys labeled it the worst conceivable PR move. Defense counsel were practically toasting in the streets. But here's where it turns hazardous. Within 48 hours of that media briefing, someone doxed Judge Rossi's home coordinates online, uploaded it to 3 separate forms, attached a snapshot of his residence. The U.S. Marshals Service instantly ramped up protection. Rossi's wife and college-age son were moved temporarily. The Bureau is probing the leak. It's coercion. One court security officer mentioned off the record, "They're signaling a warning. You hunt us, we hunt you." The DA's office officially slammed the leak, published a memo calling it abhorrent and pledging unity with the inquiry. But here's what's curious. They still haven't apologized for bribing Witness 9, still haven't admitted fault on the actual malpractice. The leak they denounce, the behavior that sparked this whole disaster, they're still backing it. And the Department of Justice? Crickets. Total ear-splitting silence from D.C. No comment from the Attorney General, no nod from the Deputy AG, zero from the Office of Professional Responsibility, just silence and bodyguards, and a magistrate who now has to check his rear-view mirror every time he marches to his sedan. This isn't fading, it's intensifying, and the actors who engineered this scenario, they aren't folding, they're striking back. But here's what's nagging me. Where did the funds actually originate? We know it routed through a holding firm, we know who grabbed it, but the wellspring is still blank. Why did the state fight so viciously to keep those banking logs classified? They realized what was inside, they had to realize, so why not plead the case out? Why not make it vanish quietly? Insiders are telling me the FBI probe has already stretched beyond Witness 9, multiple subpoenas served, multiple players being grilled, and here's the nugget that made my blood freeze. Rodriguez's forensic auditor, the one who flagged the wire transfer, she's had 2 knock-and talks from federal suits, not to debrief her, to interrogate her about her own tax returns. The state isn't just shielding themselves, they're playing offense. Judge Rossi reportedly mentioned to peers he anticipates heavy blowback and that he's braced for whatever lands. Something is brewing. Influential figures despise being unmasked, and when influential figures feel cornered, they don't retreat politely. When this cracks, truly cracks, we're going to discover exactly how deep they're willing to dig. Subscribe now because this saga is nowhere near done. Smash that notification bell. When the FBI report lands, when more identities float up, when the next domino tips, I'll be here tracking it. You're going to want to witness what follows. Here's where things sit right now. Elias Thorne is an unchained man. He's allegedly conferring with civil rights firms about potential malicious prosecution claims. The figures being tossed around? 8 figures. The lead prosecutor has been put on administrative leave, pending review. His junior partner quit 3 days ago. Neither is speaking on the record. Judge Rossi is back on the dais. His schedule is packed. He's operating as if nothing occurred, which is exactly what you'd predict from a 25-year veteran who's viewed it all. But here's what isn't in any public memo. 2 other trials from this legal unit have quietly had sentencing stalled. No reason offered, just postponed indefinitely. 3 currently jailed inmates have lodged petitions citing Rossi's decree. One of them asserts he holds documentary proof of parallel bribes in his file. And the FBI inquiry? It's still classified, but 3 agents have been staffed full-time. 3 agents on 1 jacket usually implies they expect to uncover something. The clock is running. Everyone attached knows it. But here's what keeps me staring at the ceiling. The state's reaction to all this, the resistance, the assaults on Rossi, the refusal to fold, it only adds up if they figure they can weather this, if they figure the probe will hit a wall, if they figure the machine will insulate them like it always has. Maybe they're correct. Maybe this whole affair gets quietly swept under the rug. Maybe everyone moves along.
But I've been covering this long enough to realize scandals like this don't wash off clean. There's a reason the auditor is being squeezed. There's a reason sources have gone mute. There's a reason Main Justice in Washington won't utter a single syllable. Someone is petrified, and petrified people commit blunders. I don't know what the Bureau will dig up. I don't know who else is tangled in this. I don't know if Judge Rossi just revealed the peak of the mountain or the entire mountain itself. But I know this. Whatever happens next is going to be heavier than anyone predicts. The question is, will you be tuning in when it snaps? Subscribe, notifications on, because when this story detonates again, and it will detonate, I'll be here tracking it. You're going to want to witness what follows. Something is about to